summary. His bio was really long, but I'm going to give you some of the highlights. Chair Gensler has served as chair of the SEC since April of 2021. Before joining the SEC, Chair Gensler was a professor at the MIT Sloan School of Management, where, among many other things, he taught a cryptocurrency class, which, by the way, you can see it on YouTube. It is really, really good. Thank you, Chair Gensler, for that. Before then, Chair Gensler served as chair for the Maryland Financial Consumer Protection Commission, and he has an absolutely illustrious track record of public service. He was formerly chair of the CFTC, senior advisor to U.S. Senator Paul Sarbanes in writing the Sarbanes-Oxley Act, and undersecretary and assistant secretary at the Treasury Department. Prior to his public service, Chair Gensler worked at Goldman Sachs, where he became a partner in the M&A department and later was the co-head of finance, responsible for the firm's worldwide controllers and treasury efforts. He is a native of Baltimore, pronounced with a soft D, not a hard T, and Chair Gensler is the proud father of 3 girls and a graduate of Wharton. Chair Gensler, thank you very much for joining us today.
Kears, thank you for that very kind introduction. And yes, I some days probably do say Baltimore. My thanks to the Practicing Law Institute and the 54th Annual Institute of Securities Regulation. As customary, I'd like to note that my views are my own, and I'm not speaking on behalf of my fellow commissioners or the SEC staff. Let me go back a little bit in time. On May 27, 1933, when he signed the first federal securities law, Franklin Roosevelt said, and I quote, "This law and its effective administration are steps in a program to restore some old-fashioned standards of rectitude," end quote. And for nearly 90 years since, Congress has tasked the Securities and Exchange Commission and our dedicated staff with this, quote, effective administration. We do this through overseeing the markets, registering entities, enacting rules, examining against the rules, and enforcing those rules. And today, I'd like to focus on that final pillar on enforcement. It's a practicing law institute. Why not? In the fiscal year that just ended, September 30th of this year, we filed more than 700 actions. We obtained judgments and orders totaling $6.4 billion, including about $4 billion in civil penalties. But these numbers tell only part of the story. As I said about a year ago, I think that the effective administration of our enforcement, I think of it through 5 themes: economic realities, accountability, high impact cases, process, and positions of trust. If I can quote another great person in history, is Thurgood Marshall, Justice Thurgood Marshall, in describing the scope of the federal securities law, said, quote, "Congress's purpose in enacting the securities laws was to regulate investments in whatever form they are made and by whatever name they are called. Thus, to effectuate Congress's purpose, we look to underlying economic realities, regardless of the form or the name of the securities, the funds, or investors involved. We follow, I would say, Aristotle's principles, treat like cases alike. Economic realities inform every sector of our enforcement program. To use effective administration in my speaking time, though, let me just point to a couple of cases from the past year. First, if you fail to register a security as required or to register appropriately as an investment company, you're violating the securities laws, regardless of the form or name of the securities involved. That's why when BlockFi failed to register the offers and sales of a crypto lending product and made materially false and misleading statements about those securities, we charged them. We settled, but we charged them. Second, if you improperly trade securities on insider information, you violate the securities laws, regardless of the form or name of the securities involved. That's why when a former Coinbase manager and others allegedly misappropriated confidential information to purchase crypto asset securities, we charge them. Finally, fraud is fraud, regardless of the types of investors you have defrauded and the types of securities used in the fraud. That's why when several firms, and these are multiple cases, Allianz Global Investors, Archegos Capital Management, and Infinity Q Capital Management, or in some cases, their executives as well, used complex products allegedly to defraud investors, we charge them. If you defraud any investor, retail or institutional, sophisticated or not, you'll be held accountable. Secondly, nothing motivates what Roosevelt called rectitude quite like accountability. We use many tools to hold violators accountable. You're familiar with them: bars and suspensions, penalties, disgorgements, injunctions, cease and desist orders, undertakings, admissions, criminal referrals, allegations, or what's called finding of facts. When it comes to accountability, thus the details matter. The details mattered when we held Allianz and its senior managers accountable. A key U.S. subsidiary of Allianz, AGI US, admitted to the wrongdoing and pleaded guilty in a parallel criminal action. We charged 3 senior managers, imposing injunctions on 2, continuing to litigate against the last. We imposed a penalty of about $1 billion on the firm, and moreover, as a result of its guilty plea, AGI US no longer advises mutual funds here in the US. The details also mattered when we held Boeing and its then CEO accountable. Both misled investors about the safety of Boeing's airplanes, even as 2 of them crashed, sadly killing 346 people. We charged the company and the then CEO for making false statements about the airplane's safety. Look, make no mistake, if a company or executive misstates or omits information material to securities investors, so you misstate, you materially misstate, you omit information to securities investors, whether it's in an earnings call, on social media, in a press release, on your website, will pursue a violation of securities laws. The details mattered when we filed a complaint holding Vale, a Brazilian mining company, accountable. Vale told the public that their dams were safe, all while they allegedly manipulated safety audits. Sadly, the dams collapsed. Many people lost their lives. We charged Vale for allegedly making misleading disclosures and engaging in other deceptive misconduct. Our litigation's ongoing. Allianz, Boeing, Vale are but a few examples of how we hold violators accountable. Now, if you are a victim of fraud or any other violations of securities laws, then the highest impact case is, of course, the one we bring against those who wronged you. But I think the lawyers who are listening today or in the room, when you think about high impact cases, you likely think of a different kind of matter. Cases that send a message to the markets. You know the cases where you write the memos to your clients about them, and hopefully market participants take notice of these high impact cases and change behavior. Let me just highlight a couple from this past year. The first relates to books and records. You might think, books and records? Well, since the 1930s, record-keeping obligations have been vital to market integrity and the SEC's effective administration. So last year, we charged JP Morgan Securities for widespread failures to meet these books and records obligations. Employees, supervisors, and even managing directors were conducting and failed to maintain off-channel communications through WhatsApp, text messages, personal email accounts. Cases like these had happened before. Frankly, though, some market participants did not act as if they got the message. So we imposed a fine, a penalty of $125 million in that case, nearly 10 times what we had imposed in previous similar matters. And also, they admitted their misconduct. What did we do next? We then did a sweep for similar violations. In October, we charged 16 additional financial entities for similar record-keeping failures, all of whom admitted their misconduct, combined settlements over $1 billion. We ordered undertakings against the 16 firms designed to remediate past failures and prevent future misconduct, and our investigation is ongoing. I hope this sends a message to other registrants. Books and records matter. We will strive to ensure that penalties are not seen as just a cost of doing business. We will use sweeps, initiatives, and undertakings to shape market behavior. Second, high impact cases aren't just about those that have high penalties or high profile. They also can be cases where we reward good behavior. One such case we did this in recently, rewarding good behavior at a company called Kronos Group Inc., a NASDAQ-listed cannabis company based in Toronto. Not all of you have heard of it. But upon discovering material accounting errors, Kronos promptly self-reported, cooperated with their investigation. We charged the company and a former insider for the violation, but we did not impose a penalty. This hopefully could send a message. If you mess up, and people do mess up sometimes, it's human nature. Come in, talk to us, cooperate with the investigation, remediate your misconduct. Now let me talk about process for a moment. Process is about fairness to the market, to the public, to those who are investigated, and to those who are wrong. Process is about timeliness. I think we should work thoroughly and expeditiously to bring matters to resolution. Process is about working with our partners at the federal, state, and international level, as well as self-regulatory organizations. One recent example that highlights this is the cases of Trevor Milton and the company he founded, Nikola Corporation. We allege that, among other things, Milton misled investors by saying that Nikola had, quote, billions and billions and billions and billions of dollars in orders. Now, those familiar with Carl Sagan might say it sounds a bit like a botched Carl Sagan quote, more so than full, fair, and truthful disclosure. We charged Milton and Nikola with fraud. Just last month, thanks to the work of our partners at the Department of Justice, Milton was found guilty in federal court. That earlier case, BlockFi, in bringing that action, several state securities regulators and the National American Securities Administrators Association played key roles. I thank all of our partners involved in these matters in the recent years. Finally, process is also about following the facts and the law wherever they lead. When the facts demand a fight, we're not afraid to go to court. Over the recent fiscal year, we litigated jury or bench trials in 15 cases in federal district courts. We won favorable verdicts in 12. If the facts and the law merit that we do not make a case, though, I'm comfortable with that. We should follow the facts and the law where they take us. Finally, to all of the securities lawyers I'm speaking with today, you play an essential role to the clients that you counsel, but you also have a role as gatekeepers in upholding the law. For instance, today's event takes place in the state of New York, and those of you that know New York law and passed the bar, you might remember that state courts describe the role of an attorney as a position of trust, a position of duty, and authority conferred by governmental authority for a public purpose. New York. We want you to succeed in meeting those standards of rectitude. When lawyers or other gatekeepers, auditors, underwriters, and such breach their positions of trust and violate the securities law, we'll not hesitate to take action. During the recent year, for example, we did charge an attorney for his role as an unregistered fraudulent in an unregistered fraudulent securities offering, and we suspended him from practicing before the SEC attorney. We also are litigating an action against an attorney for his alleged role in a would-be pump and dump scheme. In addition to other remedies, we seek an injunction to prohibit that individual from providing legal services regarding securities offerings and sales. It's not just lawyers. In June, we charged Ernst & Young for cheating by its audit professionals on ethics exams. These are professionals whose job, amongst other important responsibilities, is to catch cheating by clients. Yet, these same professionals who are supposed to catch cheating by their clients cheated on their own ethics exams. Further, the attorneys at Ernst & Young who were aware of the conduct failed to bring those problems to our attention despite direct requests. What an egregious failure of the public trust. In charging EY, we imposed remedial actions, $100 million penalty, the largest of its kind against auditors. If issuers or registrants in our markets are relying upon them, it doesn't matter where the gatekeeper is located, here or abroad. This fall, we charged Deloitte China, an audit firm who essentially asked companies to complete critical parts of their own audits, a plain violation of professional conduct. Deloitte China abdicated the responsibility as a gatekeeper, and among other things, we imposed a $20 million penalty. We also filed actions against 4 underwriters, Oppenheimer, BNY Mellon, TD Securities, Jefferies, charging them with failing to meet disclosure requirements when offering municipal bonds. This, too, was the first of its kind. As I said last year, if your client is considering a course of action that takes them right up to the line, just a suggestion, keep them back from the line. Let me conclude on this. Another key date in the history of the SEC. On May 23rd, 1934, nearly 1 year after Roosevelt spoke about standards of rectitude, he received a letter from one of his key advisors, Felix Frankfurter, who later became a Supreme Court justice. And Frankfurter was writing Roosevelt about how to staff this new SEC, regarding effective administration and how the SEC might succeed. And what Frankfurter wrote was, quote, "You need administrators who have stamina and do not weary of the fight, who are moved neither by blandishment nor fears, who, in a word, unite public zeal with unusual capacity." That's our remarkable staff, 4,500 strong. Public servants here at the SEC, cops on the beat, uniting public zeal with unusual capacity. I thank each and every one of them for their service. I thank them for their rectitude. Thank you. Kiers, I'm going to hand it back if you've got a few questions.
Thank you, Chair Gensler. It's Meredith Cross. Nice to see you.
Good to see you again, Meredith.
It's been a while. One day in person, maybe. We really appreciate your providing remarks to the audience today. As you probably know, this is primarily a group of people that advise public companies on disclosure, governance, and things like that. And it's very good for them to hear the perspective of you on the enforcement side, because it certainly keeps all of them and all of us on our toes. So we appreciate that. I'm going to lead us off with some questions. We really appreciate your taking some. So first off, do you have messages you would like to share for public companies and their advisors going into annual reporting season this year?
I think it's just at the core of what I said just a few moments ago. Investors are making decisions based upon those filings. And that's our basic bargain, is investors get to decide what risks they take. But the companies, your clients, need to make full, fair, and truthful disclosures. Roosevelt called it the Truth in Securities Act, actually. We're not a merit-based regulator, but we are a disclosure regulator. So I would say making sure that the material information is there and that it's accurately reflected in a usable way. And that's the core. And I think it's true whether it's in the annual report or whether it's in social media, whether it's in earnings calls. That would be the core thought.
That's very helpful. Thank you. And next question goes to all the exciting things you all are up to there now from the standpoint of public companies. As the agenda for this conference makes clear, the SEC's action-packed rulemaking agenda for public companies is of great interest to this audience. Reminds me of when I did 60 Dodd-Frank rules back in the day. Folks are trying to get ready.
Meredith, you did more rules than we have on our unified agenda. Thank you for just mentioning that, and particularly for the press that are listening.
And I had to buy a whiteboard on Amazon that took up my whole office to keep track of them all, because Congress gave us a lot of rules to write. In any event, folks are trying to get ready for what is.
You left us 8 to do. So 8 or 9 of what we're currently doing are still from Congress's Dodd-Frank mandates.
It was a lot. We can all agree it was a lot, and I understand needing to get them done. I tried really hard. So folks are trying to get ready for what's to come, and we practitioners get asked daily what is coming and when. Can you share any thoughts on your priorities and how you think about challenges companies may face when the many changes do come?
Well, I think on the disclosure side, we've made proposals, and we benefit from your comments, and keep sending them in. Um, we've made proposals. In terms of disclosures, pay versus performance, disclosures around stock buybacks, disclosures around cyber risk and climate risk. So there's those handful of things that we've proposed. Continue to weigh in. It's not just in your written comments, but also the meetings that staff have and the five of us as commissioners have individually with you are really helpful. In terms of what's yet to come, we're still looking at a rule that was put in place about 2 years ago around human capital disclosure, and whether we've learned some things over the first 2 years of those disclosures, and whether we do something around enhancing those. But again, we're a disclosure-based anti-fraud agency, making sure it's full, fair, and truthful disclosures. We're not a merit-based regulator. So as we sort through those comments, what we're really sorting through is investors on one side are making decisions, for instance, around cyber risk or climate risk. Issuers on the other side are already making a significant amount of disclosures that investors are finding important in their decision-making, material in their decision-making. And so even before we finalize rules, I would go back to your first question, make sure those disclosures that your issuer clients are making, whether it's in cyber, whether it's in climate, whether it's in human capital or elsewhere, that investors are finding meaningful, make sure that they're truthful and clear and accurate. What we're trying to do is to help to bring some efficiency through consistency, comparability, and usefulness of those disclosures.
Okay.
Thank you. All right, Chair Gensler, I have one more question. I'm going to go in a slightly different direction, if that's okay. One of the issues that international companies face in particular is an increasing number of rules around the world on a variety of issues, ranging from corporate governance, climate, human capital, and much more. Is there any chance of greater harmonization among the rules adopted by the SEC and some of the other leading capital markets regulators? So, to use one example on climate, is there any hope of one standard for disclosure across jurisdictions?
So we're fortunate, and I think the issuer community is fortunate that a group put together by the Financial Stability Board in 2017 came up with a framework. It was still higher level, principles-based, but a framework around climate risk disclosure called TCFD. You may be familiar with it. And around the globe, to answer your question, hundreds, thousands of companies have adopted that framework. Again, it's in a fragmented way. People have adopted it in different ways. So regulators around the globe in Europe, Asia, US, Canada, Australia, Japan are looking at that TCFD framework and trying to be inspired by that, because it's what companies are already largely looking at. It's what investors have started to look at. So I would say, yes, Kears, there's a lot of looking at that framework, but the details, of course, matter. And so I would say, and continuing to comment, where you think there's something on, let's say, the definitions that is not aligned between the international approach through the International Sustainability Standards Board, ISSB, or not aligned with the UK or Canada or elsewhere, highlight that for us. Help out and send an additional comment letter in maybe. The comment letter we reopened actually closed again yesterday, but we tend to look at comments even when they come in after the close of those periods. I do think that we have a little bit different jurisdictional authorities. And I want to assure everybody, we live within the authorities that Congress grants us and how the courts interpret those authorities. Other jurisdictions may have different authorities. So to that extent, there may be other jurisdictions that might have some requirements for disclosure that we would not have.
Okay, final question is one of your favorite topics. This is about digital assets.
I thought you were going to ask about my daughter.
We can go there next. I'm happy to go there next.
I think we should talk about my grandkids.
Only if we bring the pictures out on stage. So Chair Gensler, you've been very clear about the application of the Howey test to investment contracts. In practice, can you talk a little bit about how the staff is engaging with the industry on these points? And do you expect a rulemaking or something else to make clear how digital assets issuers can register digital assets? For example, you gave a speech earlier this year where you mentioned Regulation AB as a potential model for digital asset disclosure. Is that something that issuers should be looking at?
Several points. One is, and I quoted Thurgood Marshall earlier, it was from a Supreme Court case, I think, around Reeves in the 1970s, when he said that Congress painted with a broad brush and in creating the securities laws. And it wasn't about names or labels. It was about folks raising money from the public and the public anticipating a profit based on the efforts of others. That's the Howey test. That's rather clear. And if you think about the crypto ecosystem right now, thousands, nearly 10,000 tokens, the public is anticipating and hoping for a better future, investing in these tokens, and they find a website, and there's a group of entrepreneurs or developers behind that website. And in fact, to the 1,000+ lawyers at the PLI conference here, just think about it. If you have a client, you have somebody that signed an engagement letter. There's somebody. You're not doing your work for a distributed, decentralized, diffused community pro bono. You've got somebody signing that letter. Well, think about the public as anticipating profits generally based upon the efforts of your client in the middle. I think here's the challenge that we're facing is getting the intermediaries up and registered. This is a rather centralized area, actually. There's only a handful of meaningful sort of market share companies in the crypto exchange space, in the crypto broker-dealer space, in the crypto lending space. They tend to have dozens, if not hundreds to thousands of tokens on them. And it's statistically improbable that they don't have securities on those. You talk about the Howey test. I think about the platforms, the intermediaries. I remind you that when Roosevelt worked with Congress, they started with, in the 33 Act, an issuer-based disclosure regime. But it didn't take but a year. They knew they had to do more. They had to also regulate the brokers and the other intermediaries. So in 34, it was the exchanges and the broker-dealers, and in 40, it was the investment companies. And similarly here in crypto, I think it's so important to get those intermediaries within the investor protection perimeter. And we're talking to significant intermediaries, both in what I might call the crypto incumbents, as well as traditional financial firms that say, I have customers that want to invest here. We are neutral at the SEC. I'm certainly neutral about the technology. And that's our role. Our goal is to get investor protection around this space. And that's also the law, because think about the tokens that people are investing in, with a few exceptions. And though those exceptions might have a lot of market value, there's still thousands of tokens that are really about that Howey test you mentioned earlier.
Great. Well, Chair Gensler, I just want to thank you again on behalf of PLI and all of the audience members for your time this morning. We really appreciate it.
Thank you very
And
much.
I thank you, Kears and Meredith, for your service, because I know that you also served in the public. So be well, and to all your members.
Great. Thank you.
Thank you.
So our next panel starts at 9:45. So if the folks from the panel want to come on up, and we'll get started in a few minutes.